So in the previous lesson, what we did was take a look at a model introduction for a generalized exam question for A-level politics. So we looked at whether or not we could look at this as an A-star model response to the question being that the sovereignty of Westminster has been undermined, and we're asked to discuss that particular statement. Now, what I'm going to do in this lesson is go through two major chunks of this essay, so two paragraphs. The reason why I haven't done three is because, as we'll see, the two are quite long, and given the fact that we spent about 20 minutes on this one introduction, I didn't want to spend like 3 hours on three paragraphs. So you should get the idea by looking at two, because I've written the two in ways that really highlight the kind of arguments that you can make and the kind of structure that you can do. So I've made it so that they are two that are potentially a little bit distinct from each other in a number of key ways. So let's just remind ourselves of the introduction to give us an idea of where we're going to go with this essay. So it says here that the sovereignty of Westminster has been undermined, and we're asked to discuss that particular statement. And I wrote the following. I've said that, oopsie daisy, that the doctrine of parliamentary sovereignty states that Westminster Parliament is the supreme lawmaking authority. However, recent developments have challenged the view that Parliament is truly sovereign and that lawmaking authority of Westminster has been undermined. Such challenges come in the form of the UK's previously existing membership of the European Union and the transfer of political authority to a supranational regional institutions, the impact of the 1998 Human Rights Act and the implementation of the European Convention on Human Rights into UK law, and legislation passed to transfer legislative authority to devolved institutions. However, the most accurate interpretation is that while these three examples provide prima facie evidence of an undermining of the sovereignty of Westminster, when one scratches beneath the surface, it is clear that Westminster Parliament has retained its sovereignty. This will be shown with reference to each of these examples. So that is the essay that, the introduction that I have highlighted. I have noted that we have a very quick and basic introduction at the start over here. So if we just highlight this, highlight that like that. So this is I'll keep the highlighter up as well. So this is a very basic, just a definition of what parliamentary sovereignty is. I noted in the previous lesson that shouldn't take very long at all for you to write. You should just be able to write that in literally a minute at the start. It just provides a nice bit of clarity. It doesn't necessarily get you any extra marks, such that if you didn't include this, you would get a B rather than an A or an A star. That's not necessarily how these essays work. The next thing is looking at the debate. This part here highlights the debate that is going to be had. It is basically setting up what the debate is. The idea that parliamentary sovereignty exists. It is the supreme lawmaking authority principle. However, recent developments have challenged this view. And then what I've done is I have essentially done something called signposting. I've established and set up all the things that I'm going to be talking about in this essay. So I've essentially told the examiner within the first few sentences of this essay what the arguments are going to be had, what discussions are going to be had. I'm going to be discussing the European Union, I'm going to be discussing the Human Rights Act, and I'm going to be discussing devolution. Those are the three things I'm going to be discussing in this essay. So it gives the examiner an indication of where this essay is going to go. And then the final and most important piece of this introduction is, of course, the argument itself. You have to highlight and identify what your argument is going to be in the introduction to your essay. You have to explain what you are going to be doing. An introduction is essentially a roadmap for your examiner. What the introduction should do is explain what you're going to do, so i.e. what your argument is going to be, and how you're going to do it. I.e., what are the things you're going to talk about? How are you going to explain and prove your argument? So this part here is what your argument is going to be. Okay, that is the argument, what I'm going to do. And these three things here are how I'm going to do it, how I'm going to actually explain to people that the most accurate interpretation is that Parliament has retained its sovereignty. That is what we're doing here, okay? Now, in terms of structure and in terms of the order in which you do that, it doesn't necessarily matter. For some people, you could put the argument up here and then explain how you're going to show this argument afterwards, or you could do it the way I've done it. It doesn't really matter in terms of the flow of the essay, as long as it flows and as long as it is written coherently, and as long as you have these things in here, you're going to have a very, very, very well-written introduction. Okay? If you want more on this, look back to our previous video that we've done on the introduction and achieving an A-star introduction. We spent about 20 minutes looking at this one paragraph here. Let's look at the other things now. Let's look at the rest of this essay. Now, in terms of the rest of this essay, I haven't written a conclusion yet, and I haven't done a third paragraph. So what we're actually looking at is the European Union membership and the Human Rights Act. We're not touching on devolved institutions. Now, in reality, if you do 3 points, make 3 points, that is sort of the golden number of points, or the golden number of paragraphs. It seems to be the sort of most that you can do well in the time that most people have allotted to them. So generally speaking, try and aim for 3. Now, that does not necessarily mean you can't write a really good essay with 4 points, or with maybe only necessarily 2 points, although some exam mark schemes would specify you have more than 2, actually have specific number of points. So always try and aim for 3. Every single essay you write will have at least 3 points that you can make. So this essay here, The Sovereignty of Westminster Has Been Undermined, has way more than 3. There are lots of different things that we can talk about in terms of the sovereignty of Westminster, but here are 3 here that we have that we're going to talk about, that most people would talk about. Most people would talk about devolution, most people would talk about Human Rights Act. So in terms of these paragraphs, let's start with the first one here, which is the one relating to previously existing membership of the European Union. I'm going to read through it first, and then we'll talk and unpack it in a bit more detail. Now, I should just be very clear to note that when it comes to writing essays, there is no single one right answer for how to do an essay. All essays are very different. Essays can be written in different ways and still achieve the same amount of marks, okay? So this is to suggest that if you read this and think that your essays are written in a different way, is not to suggest that your essay is wrong and that mine is the only correct way of doing it, or even that there is nothing wrong with this essay, because there are always points at which you can probably improve. The idea here is to get across the general key requirements for an essay of this nature and to get a high mark in these exams, okay? So let's think about it. Let's go through the first paragraph, all right? So let's read it. So the UK's previously existing membership of the European Union has been argued to present a challenge to Westminster sovereignty and ultimately lead one to the conclusion that it has been undermined. A number of different types of legislation from the European Union is directly effective onto member states, such that, according to the case of Costa and the NEL, the member states would have to apply EU law into their domestic jurisdiction. This clearly indicates an undermining of parliamentary sovereignty, since it means the European Union has the ability to enforce its own lawmaking abilities within the jurisdiction that is historically the remit of Westminster Parliament. The primacy of EU law has also been upheld in the UK judicial system in the case of our Secretary of State for Transport, where the law lords ruled that the British courts had the power to disapply UK parliamentary statutes in replacement of EU law. Nevertheless, it is more accurate to argue that not only does EU law no longer undermine parliamentary sovereignty, it also never did. The enforcement of EU law in the UK has always been done under the auspices and authority of the European Communities Act 1972. This act provides that the UK becomes members of the European Union, as well as giving the EU power to enforce the law within the UK's jurisdiction. This means that, while the European Union did have the authority to implement law within the UK jurisdiction, it was done under the authority of Parliament through this legislation. In addition, since the UK withdrew membership from the European Union in January 2020 and membership from the single market that same year, it means that the law of the European Union subsequently passed no longer applies to the United Kingdom, therefore supporting the view alternative to the statement in question. Okay. There are a couple of things that I would note that are important to make clear at the beginning here. So firstly, this is relatively quite a lot of text for a single paragraph. And the reason why is obviously because I've typed this out and it's very quick to do. Somebody who is sat in an exam writing this out might not be able to get this much information out. Okay, so if you are thinking about writing an essay in the time that you are allotted for such an exam question, and you're struggling to get this amount of information out, that doesn't necessarily mean that you've done bad or that you've got a low grade. It just means that essentially what I've done is typed it out. So I've written in a kind of quite a lot of I've written down quite a lot essentially. Now, that doesn't necessarily also mean that you can't if you're a particularly fast writer, or if you don't, or if you just know exactly what you're writing down already. So, fair play to you if you can do that. Just bear that in mind, okay? Bear that in mind when we go through this. So let's think about the things that we're going to talk about here. So, firstly, we are talking about the argument that is presented by the other side here. Okay, so the argument, essentially what I'm doing in this essay and what I've shown in the introduction is that I'm positioning myself in contrast to the statement in question. I'm basically disagreeing with the statement in question, but I'm also making clear that there is some relevance, or at least some credit to that argument, okay? That there are some examples that we can see that give evidence prima facie of an undermining of Westminster sovereignty. So what I do at the beginning in this part is I just highlight the argument that I am going to be ultimately disagreeing with. I'm looking at the fact that UK's previously existing membership of the EU has led to some making the argument that it has eroded or undermined Westminster sovereignty. I have then explained why that is the case, why people have that opinion. Why is it the case that people believe that membership to the European Union has undermined parliamentary sovereignty? Well, I've done so using specific evidence and specific examples. So I've talked about the principle of direct effect, which is a principle within EU law that essentially means that certain pieces of legislation are directly applicable onto the member states. And I have even highlighted a case that illustrates this, the case of Coster and ENEL. Now, this isn't necessarily stuff that you might have found in your exam textbooks for A-level politics, but this is, I mean, just trust me on this, this is true, okay? As somebody who researches law, this is something that actually does exist. And you might have actually come across it as well, so, this is good information to apply. And then I've explained the evidence for this argument. And then I've also looked at why I've talked about this specific evidence in question, okay? So I've highlighted firstly up here that this is the argument that some people have in relation to the statement in question. I've provided evidence to that particular claim that parliamentary sovereignty has been undermined, and here's why: direct effect, Coster and ENEL, etc., etc. And then what I've done is I've explained this evidence. Okay, this down here is an explanation of the evidence. Now, essentially, whenever you are providing evidence in an exam question, whenever you are writing the date of something, or citing a particular statute, or citing a particular case, or any kind of political event, keep in the back of your mind the question: why am I talking about this thing? Why am I talking about the case of Coster and ENEL? Why am I talking about the fact that EU law is directly effective onto member states? Why is that the case? Why am I doing that? And the reason why I'm doing that is because it shows clearly that it is undermining parliamentary sovereignty. And I'm linking this to the question. I'm linking this back to the statement in question. This clearly indicates an undermining of parliamentary sovereignty, since it means EU law has the ability to enforce its lawmaking abilities within the jurisdiction of Westminster, of the Westminster Parliament. I'm explaining why this evidence is relevant to the exam question. That is something that you should keep in mind, in the back of your mind at all times. I then go on and apply even more evidence here. So we talk about the fact that even in the UK's judiciary, in the case of our Secretary of State for Transport, that the House of Lords has already argued that UK courts can disapply parliamentary statutes. Okay, you could put this bit up here if you wanted to, and have all your evidence together in one big chunk, and then explain this down here at the bottom. And that might have been a better way of structuring it. You can do that and still get very high marks. You can have it where you have your point, where you have your evidence, and you explain your evidence, okay? You're explaining why this evidence is relevant. Think in the back of your mind at all times, why am I telling the examiner about the case of R and Secretary of State for Transport? Why is that relevant? Well, it's relevant, because it indicates an undermining of parliamentary sovereignty, okay? The next bit is the assessment and looking at the argument in more detail, okay? I'm talking about, this is the other side's opinion. This is the opinion that I disagree with, okay? And so I have to essentially disagree with this opinion. And I have to explain why I disagree with this opinion, okay? And that is down here, okay? So I've put, nevertheless. Okay, what does nevertheless imply? It suggests that, despite the evidence that you have here that suggests parliamentary sovereignty has been undermined, I'm going to argue why this is not the case, why parliamentary sovereignty has not been undermined despite this evidence that we have up here. Okay, so I've put, nevertheless, it is more accurate to argue. And I've essentially split this into 2 points. I've said that not only does EU law no longer undermine parliamentary sovereignty, it never did. And what this essentially does is it allows me to talk about, firstly, Brexit, on the one hand, the fact that even if all of this is true up here, even if all of this is true and there is no evidence to refute it, it would be irrelevant anyway because we've left the European Union, and so therefore it no longer applies. But I also make it clear that it never did. It was never relevant. Even if we were still members of the European Union, it was never relevant. And I do so using evidence, okay? I do use some evidence to show that. So what is true is the case that even though European Union law did historically apply to the United Kingdom in such a way as here, and as cited by the House of Lords and by the European Court of Justice, this is all done under the auspices, under the remit of the European Communities Act. So essentially, the European Union can, or it used to be able to apply its law to the United Kingdom, but it could only do so because Parliament allowed it to do so because of the passage of the European Communities Act. So I've essentially argued my point. I've made my argument that while on its face, prima facie, there is evidence to suggest that UK Parliament has been undermined in terms of sovereignty, it is nevertheless the case that when you look at it in more detail, Parliament has still retained its sovereignty. It retains its sovereignty in this regard. And then I finally finish by talking about the fact that all of this is technically irrelevant because we have left the European Union anyway, and so therefore there is no longer the application of EU law into the UK's jurisdiction. That's one way in which we can describe and look and analyze evidence here, okay? Notice something interesting. If we think about it really, I'm not using that much evidence. I'm not using that much specific evidence or specific information that you have to memorize before an exam. I've cited Costa and the NEL, I've cited R and Secretary of State for Transport, and I've cited the European Communities Act of 1972. I've not divulged and just described and explained how the EU works and how the UK system works and gone into all this kind of detail, because I don't need to. I only need a few pieces of evidence and then taking that evidence and doing a really good amount of analysis on that. That's what's more important. It's more important to have smaller pieces of evidence, but to really explain that evidence in detail and explain how that evidence actually relates to the question, and to analyze that evidence and to talk about how that evidence is relevant for your argument, rather than just to spend the entire time just basically rewriting the textbook out in your exam, okay? So worry more when you are revising about good essay title structures, basically looking at a piece of evidence and explaining how it is relevant to the question, rather than spending all your time memorizing all this evidence instead, okay? Because you don't actually need that much. And we're going to get to the second paragraph in a second to show that as well. And this is the case for all A-levels, by the way. If you are somebody who's studied A-level history, you don't need to know the dates and to be able to cite the dates of every single thing that happens and every single monarch that does whatever, okay? Instead, just have a few pieces of good evidence that really, really, really does a good job at showing your argument and proving your argument instead. Okay, let's get to the second paragraph, and then we can finish here. Second paragraph is significantly longer. Again, bear in mind that not only is it longer because I've typed it out, I've also used double spacing as well, just to give us more room to work with. So it maybe looks longer than it actually is as well. So, secondly, it has been argued by critics of the view that Parliament retains its sovereignty, that the Human Rights Act of 1998 limits and undermines Parliament's ability to make law. The Human Rights Act 1998 incorporates the law of the European Convention on Human Rights, the ECHR, into domestic legislation, thus allowing UK courts to adjudicate on matters which were historically the remit of the European Court of Human Rights, the ECTHR. The Human Rights Act undermines parliamentary sovereignty, since all other pieces of legislation have to be compatible with provisions therein, as per Section 19. This involves, in the first reading of a bill, the minister in question issuing a statement of compatibility with the Human Rights Act. In addition, where there may be incompatibility with the Human Rights Act, a court can issue a declaration to ensure that that legislation be changed. Prima facie, this appears to be a significant undermining of the principle of parliamentary sovereignty, specifically the rule that Parliament cannot bind its successors. However, in reality, while the declaration of compatibility is legal in nature, Parliament does still retain the power to ignore it. Therefore, its decision to comply with would be one of a political obligation, not an undermining of legal sovereignty. Nevertheless, there is still some merit to the argument that parliamentary sovereignty is undermined by the Human Rights Act. This is because the Act is considered to be constitutional, and the Court of Appeal, in the case of Thoburn and Sunderland City Council, has made clear that the constitutional statutes may not be repealed impliedly by Parliament. Therefore, at the very least, there may be some merit to the argument that parliamentary sovereignty has been undermined by the Human Rights Act. However, this is a question of legal ambiguity. So what am I doing in this paragraph? Well, I'm doing a few things in this paragraph. Firstly, I am highlighting what the argument is. The argument, again, is, well, Parliament has been undermined in terms of its sovereignty because of the Human Rights Act. And then, what have I done? Well, I have explained why this is the case. I have used evidence to explain why this is the case. And the main piece of evidence, of course, for why this is the case is, of course, the compatibility with the Human Rights Act provisions. So firstly, Section 19 of the Human Rights Act makes it clear that wherever a bill is passed into law, it has to be very clear that that bill is compatible with the Human Rights Act. If it is not compatible with the Human Rights Act, a court can issue a declaration of incompatibility. It can say, well, this is not compatible with the Human Rights Act, this legislation, and the result of that is that Parliament then changes the legislation or repeals the legislation to essentially make it so it was or is compatible. That is the evidence, okay? It's very easy to explain why that evidence is relevant to the question, because it clearly shows that Parliament has to undermine its sovereignty in making sure that it is compatible with the Human Rights Act. And I've even cited a specific tenet, a specific principle of the parliamentary sovereignty doctrine, which is that Parliament cannot bind its successors. Well, if the Human Rights Act was passed in 1998, and every subsequent Parliament has to ensure that there is a compatibility with the Human Rights Act when they pass legislation, then surely does this not imply that Parliament can bind its successors and therefore undermine the principle of parliamentary sovereignty? That is the argument that I am presenting here. However, I dismiss this argument. I undermine this argument by saying that even though this is all the case, okay, the fact that Parliament seems to have some kind of obligation to ensure that it is compatible with the Human Rights Act when it passes legislation, this is a political obligation. This is a limitation of political sovereignty, because in reality, Parliament can still do whatever it wants. Parliament can still issue a piece of legislation that is incompatible with the Human Rights Act, okay? That is the argument that I've presented here. However, this is really where we start to think about some of the debate that you can have and to really come to a conclusion that you don't necessarily have to sit on one side of the argument versus the other side of the argument. You can sort of sit in the middle to an extent, because here I've talked about the case of Thoburn, the case that basically says that there are certain constitutional statutes, and in order to remove some of these constitutional statutes, we have to expressly repeal them They can't just be impliedly repealed by Parliament. So, as a basic bit of just explanation and background, one of the principles of parliamentary sovereignty is a principle that is known as the principle of implied repeal. And essentially what this means is, if I pass a law in, let's say, 2005, and then I pass a law in 2009 that completely contradicts that previous law that was passed in 2005, then what that means is, essentially, I have implied that I am repealing that first law, because what I'm doing is contradicting it in the second law. And so essentially that piece of legislation is repealed by way of some kind of implied act, rather than expressly being repealed. Rather than me actually saying I'm repealing this law, I've sort of implied that I'm repealing the law by contradicting it. That's what the doctrine of implied repeal tells us. And the case of Thoburn suggests that a constitutional statute, like the Human Rights Act, like the certain pieces of devolution, or the European Communities Act, or the European Withdrawal Act, may not be able to be impliedly repealed in this way. It might be the case that you have to expressly take away that legislation in order for it to be the case. Now, what does this actually suggest then? Well, it suggests that there could be some legal ambiguity, and so you can essentially come to the conclusion that parliamentary sovereignty may be undermined in some ways, but not necessarily in other ways, essentially sitting on the fence in some ways at the end of this argument. But ultimately, you can also come to the conclusion that while the doctrine of implied repeal is undermined here, by the case of Thoburn, the doctrine of parliamentary sovereignty is still relevant and is still not undermined by this particular point down here. So maybe if you had more time, or maybe if I had more time, I would have written another point down here saying that this is only an undermining of the doctrine of implied repeal, not the doctrine of parliamentary sovereignty. So a little bit of ambiguity there in terms of my writing at the bottom. And you could probably, if you wanted to, stretch this into 2 paragraphs. You could probably write 2 paragraphs just about the Human Rights Act. You could talk about the Human Rights Act with reference to incompatibility, like this is done here, and you could talk about the Human Rights Act with reference to the state of the Human Rights Act as being a constitutional statute, and the case of Thoburn that is written here. So this could actually technically be a separate paragraph, and you could write this separate paragraph down here if you really wanted to. And this is again looking at the kinds of details that we have for this essay. So these are 2 paragraphs. Okay, we have again a point that is made, the evidence to show that to basically highlight that point. I'm explaining why this evidence is relevant, and then I'm talking about the debate. I'm talking about undermining that evidence and showing and proving my argument. That is what I'm doing here. In the final of these videos, I will go through and write a little conclusion. Again, the conclusion should be the quickest bit. The conclusion is basically just summing up everything that you've already done. So the introduction is essentially telling us what we're going to do. The middle paragraphs are actually doing those things, and then the conclusion is just summing up all the things that we have done. If you have any questions about this video or the previous video, let me know in the comments down below. I'll go through and answer them as best you can. Again, ultimately, the best revision that you can ever do for anything in A-level politics, or even A-level history, or any of the other subjects, is just to do practice questions, just to do problem after problem after problem, to think about the evidence, not necessarily in terms of trying to memorize the evidence, like using flashcards or mind maps, but rather taking the evidence and looking at how you apply the evidence to specific questions. That is a skill that you need to learn to get the highest grades in all of these exams.